Within the United States, a state court can exercise what we call jurisdiction and reach out against citizens or businesses of different states, or even non-residents of the United States, assuming certain basic jurisdictional principles are met. You may have heard the phrase extraterritorial jurisdiction. Question is, what is that, and how is that pertinent to your business? Extraterritorial jurisdiction is applied both within and between the 50 states, but as importantly applied either to non-U.S. citizens or businesses operating outside the United States. As such, it is critical for your business to understand these rules of jurisdiction, both offensively, that is in the case you want to bring an action, or defensively, if you are concerned about being sued in a certain jurisdiction. Certainly, a citizen of one state can sue another citizen or business that resides in that same state. That is the easy first step in this jurisdictional tree. In addition, it is always possible for an out-of-state business or firm to consent or agree to be sued or bring suit in another state. It gets a little more complicated when a person or business resides in one state but injures a person in a different state. Obviously, the injured person wants to bring the claim in his or her own home state. If the alleged wrongdoer has transacted business, that's the operative phrase, in the injured person's state, even though they do not technically reside in that state, the foreign, also called the out-of-state business, can be brought to suit in the state in which the injured party resides. The final step in the jurisdictional analysis is under what circumstances a non-U.S. resident or business domiciled outside the United States can be sued in the United States. Again, this test includes a determination as to whether this foreign entity or person has transacted business in the United States. If so, they can be brought to suit here. A good recent example of this, albeit in the criminal context, is the World Soccer Organization, FIFA. They were brought within the U.S. criminal system not because of a physical presence in the United States, but rather since the organization's computer services were located in New York City. As such, the United States Department of Justice reached out in an extraterritorial way and grabbed the executives of FIFA and compelled them to trial here in the United States simply because FIFA transacted business here, and the definition of transacted business was met by the fact that their physical servers were located in New York City. Lastly, in this regard, one cannot ignore the effect of the internet and the World Wide Web in this whole jurisdictional transacting business analysis. Using the World Wide Web to solicit business, gain business, allow people from different states to buy your product, even though you physically are not there, can conceivably subject you to jurisdiction in any state in which you're soliciting business. That is why you may see in the legalese or fine print businesses who say, for example, this is not a solicitation of business or sales in these particular states. In the event that a customer did contact their sales office to buy a product, the salespeople would have been instructed, we don't take business from citizens in those states. Now, why would you turn down revenue? Why would you turn down a sale? Because someone has determined that the local laws in that state may not be very favorable, and that we would rather not make a sale in that state than accept business and consent then to be sued in that jurisdiction. While that may generate some upfront legal expenses to conduct a more thorough analysis of under what circumstances your business can be sued in a foreign jurisdiction, that may be preferable to getting surprised upon receiving a summons to appear in a foreign court alleging that you broke the laws of that jurisdiction.